How do you become a human rights lawyer? My answer is by accident.
Hi everyone, I'm Hannah.
And I'm Summer. We're second year JD students at Melbourne Law School, and we had the honour of interviewing Justice Chris Maxwell as part of Melbourne Law School's new human rights program.
Justice Maxwell is the former president of Victoria's Court of Appeal, and prior to appointment to the Court of Appeal, Justice Maxwell earned a reputation as a fierce advocate for human rights. He was also the president of Liberty Victoria and one of the barristers on the Tampa case. We had the honour of chatting with him about all of this, as well as about his experiences at law school, his early career, and how this shaped his later contributions to human rights.
We're interested to know, when you're not working, how do you unwind, relax? What is a good time to you?
The best time for me is Saturday morning when I go to South Melbourne Market and do the shopping. I've done that for 30 years and used to take my kids when they were small. It's a wonderful, lively market, and I can just be myself. Amongst people I've got to know pretty well, the various stalls over all these years.
How do you describe what you do and I guess what you've done throughout your career to someone who's not a lawyer?
I fell in love with law by doing it. I didn't like studying it. I really enjoyed
Universal experience?
studying philosophy, but I was very distracted as a student. I was in student politics, and so I did law along with humanities. And it wasn't until I did a pro bono case in an industrial tribunal, and I suddenly realised that I was acquiring skills which could be useful to someone who was in strife, had lost his job, and this was a complaint about unfair dismissal. I then, again by accident really, worked as a policy advisor to a federal politician, Shadow Attorney General, and then he became the Attorney General in 1983. And I learned then about the whole range of contestable issues in law where law reform was necessary or desirable. And I learnt about how government functions, and that was really important learning when I came to a job in judicial administration. But it wasn't really until I'd been a barrister for 3 or 4 years that I started to think I might be able to do it competently. I felt quite unsure of my skills to begin with and wondered after a while whether I should try something else. But as time went by, as I think all of us do in practice, you get your bearings, your skills improve, your confidence grows, and your sense of relish at the mastery of legal materials, which, as I say, I didn't feel at all as a student. I just didn't really get law at that stage, I don't think. Whereas, once I started to be advancing arguments and giving advice and so on, you naturally want to be right up to date with the latest legal developments, and you want increasingly to develop expertise in a few areas. And that's continued. I've fallen even more in love with law since I've been a judge. I have found judging in almost every way more interesting and more rewarding than being a barrister. I've felt more excited by lawyering.
That's great to hear.
Wow. Yeah. I'm
nice
already, I think so many people will be heartened by hearing that It wasn't like you stepped into law school on your first day and you were like, yeah, this
No.
is my thing. I've got it.
No.
I understand everything. It's
there-
all coming easily.
There was a handful of students who were like that. My sense is that you have to be more dedicated these days than we had to be. We only had subjects were year long, so you didn't really, and not much continuous assessment, so you didn't need to get serious until September, and you cram for the exams. And yeah, I did
Those were
enough
the
to get
days.
through. Those were the days, exactly. No, and I think it's important to say, people might think, oh gosh, well, you've ended up in a top job, you must have been on the path from the start. It's absolutely not true.
I think that's really nice to hear.
Absolutely not true. And and I've had plenty of uncertainty, self-doubt along the way. I think most people do.
Back in those student days when you maybe weren't feeling as enthusiastic about your study, did you at that time have any aspirations to be a judge?
No,
Was there
none
a
at all.
class maybe?
Wouldn't have occurred to me
No.
then. I don't think I was thinking much then about what kind of legal practice I might do, whether I would be a solicitor or a barrister. I suppose once I qualified and then started doing pro bono work, I thought, well, I would like to be a barrister. Then, as I say, I had 3.5 years out of law working for a politician. By the time I came back, I again thought, well, yes, I'll proceed with my plans to be a barrister. But the only thing I thought of at that stage was, I hope I can do this.
What was the first job that you did after graduation? And how did that impact your future aspirations?
To fill in a bit more of the story, because I did well in philosophy, I got a scholarship to go to Oxford, where I did legal philosophy, not law. But then I went and joined one of the Inns of Court in London, which is how you become a member of the English bar. And so my first job really was as a junior barrister in London. And I think that confirmed my sense that that was the path I wanted to follow. As it is here, I was a pupil for, I can't remember now, 9 months, and then I actually was doing work in the courts for about 6 months, by which time my then girlfriend, now wife, said, look, I'm going back to Australia, hope to see you back there. And a few months later I returned. I could have professionally stayed working in London, but I realised
Love mattered.
Love mattered. Exactly.
When would you say was the moment that you really jumped into the human rights arena with both feet and decided that this was an area in which you wanted to leave a legacy and something that you really wanted to dedicate your time and expertise to?
I was then president of Liberty Victoria, which was really my first conscious involvement in human rights activism. Felicity Hampel, who was the president before me, now a judge of the county court, asked me if I would join the Liberty Committee and then would I consider taking over from her as president. And I said yes to both. So from the start of 2000, I was the president. And Liberty's a small but really effective organisation in advocacy for human rights. Because of Liberty's credibility, based on what had happened before I joined, we were always asked for comment or to make submissions. So we were, for example, asked to comment on the racial and religious vilification legislation which the then Labor government was developing, and we took a position saying you shouldn't criminalise this kind of speech. There are criminal offences where speech incites violence or damage, but speech which is hurtful shouldn't be criminalised. Now, that's a contestable position, but that, I suppose, gives you an example of the sorts of human rights perspectives that an organisation like Liberty brings to bear in the public debate. And that, for me, again, was a big education, because I just hadn't been thinking in those terms.
If we shift away from talking about human rights generally and your experience generally and drill down into the Tampa case, which is a really well-known case and probably your most high profile. So to begin, maybe you could tell us how you got involved and unpack the facts of the case, and then you might unpack also the legal issues and human rights issues that came to the fore. And ultimately, I guess, what was the outcome of the case?
I was an accidental traveller in the Tampa case. Well, it must have been my second year, 2001. The Tampa brings the asylum seekers to the north of Australia. Prime Minister Howard says they will not come on shore. Some very creative pro bono lawyers, not me, realised that as outsiders, with no direct interest in the proceeding, they could bring an application for habeas corpus, which is what the Tampa case was about. In other words, asserting that the asylum seekers were being unlawfully detained by the Commonwealth government, which wouldn't let them off the ship. And this was being run by Pilch, as it was then called, now Justice Connect, Public Interest Law Clearinghouse. And they had retained Julian Burnside and John Mineta, who, as I understand it, was the person who thought up the cause of action. Because I learnt that anyone can go to court seeking habeas corpus because the common law guards liberty so jealously that if you're aware of someone being unlawfully detained, you can turn up in court, provided you've got some evidence, and seek a writ of habeas corpus. So I'm sitting at my desk on a Friday afternoon having my sushi, and Julian Burnside, whom I knew a bit, rang up and said, "Chris, we're going to issue proceedings in the federal court seeking habeas corpus. We need a body to be the applicant. Amnesty International are still thinking about it, but they have a lot of decision-making processes to go through. Would Liberty Victoria be prepared to be the applicant?" And I rang the Vice President, and he agreed with me that we should. And I said, yes, put our name on the application. And then Julian said, "Oh, would you like to work with me in the case?" And as you know, we famously won at first instance before Justice North, who held that the detention was unlawful. And ironically, that decision was handed down on the 11th of September 2001, Australian time, when I went early the next morning to get the newspapers to find out what reports there were of our famous victory.
Wow. Nothing.
It was terrible scenes from New York.
Yeah.
Then the Commonwealth appealed. The appeal came on pretty quickly, and by a 2-1 majority, as you and your colleagues would know, we lost the appeal. I remain of the view that the dissenting judgment of Chief Justice Black was correct, that the Migration Act covered the field and there was no residual prerogative to repel aliens, as the majority concluded. But we were going to seek special leave to the High Court, and then the Parliament, with Labor support, passed validating legislation saying, well, whatever was done in relation to the Tampa was lawful. And of course, that's the end of the legal question. Parliament can validate any conduct it likes, and they've done that.
I just want to take the chance to jump in there and ask, in light of that, and of course relevant to our wider discussion too, would you support the idea of a federal Bill of Rights?
We drafted a national human rights bill, which unfortunately the Cabinet didn't have the courage to run with. And so we still don't have one in Australia. But yeah, this was my first time of starting to realise the tools of the human rights guarantees as a measure against which to test what government was proposing to do.
So how did you feel about the Tampa case in the immediate aftermath, and what do you think, looking back, were the repercussions legally and politically of the outcome of the case?
Liberty Victoria got a lot of hate mail. It was such a controversial topic. It was certainly good for Liberty's standing and profile as an organisation. Sadly, though, it changed nothing. We had a reunion of the Tampa team at our house in 2016, 15 years after the case, and I raised that question, and I think it changed nothing. Because, as you know, cruelty to asylum seekers is bipartisan, shamefully. And I despair, as most reasonable people in Australia despair, that we, which really means Labor, because they at least would believe in proper humanitarian treatment, are unable to think of any way of developing or selling a policy to that effect. They run for cover. And the outrageous demonisation of asylum seekers by coalition governments and demonisation of any alternative proposal makes it electorally very difficult, that's clear. But it's shameful. And but it doesn't mean it wasn't important to do at the time. You can't know what will happen in the future. And the fact that we were able to marshal pro bono forces to take on the might of the government and the press of hostile public opinion was really important, I thought. And the fact of the validating legislation and Labor supporting it, and then Howard winning the election, which he should have lost, at least in part because of his outrageous hostility to the asylum seekers, that really set the pattern for the next 20 years.
What would be necessary to sort of break that gridlock, political gridlock, around the issue of having more respects for the human rights of asylum seekers, and whether you think like the recent move away from the major parties and increasing support for like other political parties, third parties, independents, whether that maybe signifies a sort of change in the outlook of the population and kind of a greater hunger to break that gridlock and to move toward a more humanitarian immigration system.
My thought has always been that if you set out on a long-range campaign of talking about, I suppose, two aspects: why people seek asylum. Let's have a few pictures of the kind of persecution which is experienced, point one, and then what asylum seekers mean to Australia. And we've all heard these wonderful stories about refugees settling in regional cities and energising the place, doing work that others won't do, the kind of impact that the family in Biloela have obviously made. You know, they've just united the community. And the third point I'd be making is I'd be saying to the Australian people, we are a welcoming nation. Yeah. We welcome people. If someone moves in next door, we offer them flour and sugar and a dozen eggs. That's the kind of people we are. We are not hateful people.
Appealing to our national identity.
Yeah, appeal to our better natures instead of our worse natures. Of course, deep down, we're all fearful of the stranger, but we're much better than that. And that's the kind of theme which I believe, maybe I'm naive, if you did it long enough and persistently enough, public advertising, prime ministers talking about it, then I think you could change public opinion. Because we've seen public opinion changing. Climate change is a pretty good example. I mean, it's a unique topic, obviously, but so I think there is possibility, but it'll never happen unless you're prepared to be a little bit bold.
This does lead kind of pretty well into some questions we had about sort of the competing concerns that you have to weigh up as an advocate or as a judge. And we're wondering if you could tell us about a time when you have felt conflicted and how you came to a resolution.
I'll give you an example. I did a number of cases about free speech as a barrister, and I jotted them down this morning just to remind myself. One of them was going to be for a group called Catch the Fire Ministry. There is a reported decision about them, and their spokesperson was a very voluble anti-Muslim. And they were being, I don't think prosecuted, but they were being sued under the racial and religious vilification laws. And I was approached and asked, would I act for them to resist whatever the proceeding was? And I can check the reports. And I said, yes, I'd be happy to do that. The proposition being, again, this is unpleasant stuff that they're advocating, but democratic society can accommodate unpleasant opinions. And so this was going to be on a free speech basis. When I met them, I found their attitudes so hateful and extreme that I said to the solicitor, I'm just not going to do this. Now, if I were being paid for it, it might be more of a difficult ethical issue because of the so-called cab rank principle, which we can come back to if necessary. This was pro bono, so I could really choose whether I did it or not. And that was a conflict, really, between my philosophical commitment to free speech and my moral objection to the hateful attitudes they were expressing. And I just thought, well, I won't lend my skills to people who are really hateful. Now, then let's shift to a case I did for a Holocaust denier. And this is reported, Tobin and Jones, 2003. He was being prosecuted under the Commonwealth Racial Discrimination Act. And I was asked to act for him. You know what a Holocaust denier does, says, no, this is all a fiction, there were no gas ovens, this is all a Jewish conspiracy, views which I deplore. But my human rights commitment was again to restricting the scope of the criminal law's application to exercises of speech, even hateful speech. And so I developed an argument that the provision was unconstitutional because it wasn't consistent with the Racial Discrimination Convention, international, or that there wasn't a sufficient link between the sort of nonsense that this fellow was writing and the creation of any kind of hostility to Jewish people. Well, the argument failed on both counts. They held it was constitutional, and they held that you didn't need to prove that there was any connection between the speech and the development of hostility towards that group. So I mention that because you might say, well, why didn't you act for the hateful Catch the Fire people? I don't know, I suppose because I thought that the Catch the Fire people were actively engaged in current discussion and spreading their nasty attitudes. Jones was a kind of fringe person who wrote on a blog about the Holocaust, and it was kind of, he's the sort of person you should leave alone because nobody takes the slightest bit of notice of him, and to prosecute him only gives him a platform. That was the sort of argument. So,
Good distinction. That's nice.
well, whether it's plausible, I don't know, but and I hadn't thought about it until this moment. But another one I did was for a person who was being prosecuted for contempt of court because he'd written a very lurid book criticising a variety of judges. And we again acted pro bono for him on a free speech basis, saying, well, hang on a minute, a lot of this is just robust criticism which a democracy can accommodate. Courts are there to be criticised, they're not precious. Anyway, we succeeded in part. We got a number of the charges dismissed. Several of them the judge said, no, this is really very serious undermining of the integrity of that judge or that judge.
We're quite interested in that weaving together of law, morality and ethics, but as students, just how much the current law school curriculum, the core subjects, miss engaging with the interweaving of those things. And so I just mentioned that because we were wanting to ask a question there, but maybe...
No, well, let me answer that one because I feel strongly about that.
Great.
As you may know, I helped create and I still teach in Philosophical Foundations of Law, an elective in the JD. It looks as if you perhaps haven't heard of it.
No, one of our good friends is in it.
Well, and I hope you'll do it next year because if you're interested in the moral dimension...
Will we see you there?
Yes.
Oh, okay.
Yeah, no, for students like you who have an interest in that dimension, it's the only subject like it. And anyway, time doesn't permit me to go into that. But no, it's precisely because doctrinal subjects don't ask the underlying moral questions that we think this is such an important subject. One thing I've learnt is that there's a moral dimension to a great deal of what judges do and potentially what lawyers do. And I've written and spoken about the notion of the judge as moral arbiter. When I do a sentence appeal, one of the questions will be, what was the moral culpability of the offender? Well, that's a moral judgment, as we said in a recent decision. This is how blameworthy is the person for that conduct, having regard to the circumstances and their background and any impairment of mental functioning. If I'm making a judgment about reasonableness or the interests of justice, I'm making a moral judgment almost always. And in commercial law, consumer law, unconscionable conduct is an explicitly moral concept. Conduct against conscience.
And yet not taught so
and
much
not
as
taught
one.
as one. Matthew Harding and I have published an article. It's now available as a forthcoming MULR article where we deal with exactly that issue, and we say legal education needs to look at educating morally students who are capable of moral reasoning, because at least in that area you need to be able to explain to your client what unconscionable conduct means and why what they're proposing crosses the line, or a judge might think that it does. So I hope that that your law school and other law schools will finally acknowledge that you can't really be good at the black letter stuff unless you are able to think about the moral and political framework within which those rules are created and realise that they're contestable. They're not a priori truths, they are what we end up deciding on as a community or as a legislature. So for me, that's been a huge revelation of judging. It didn't occur to me as a barrister that law had that moral dimension. Now I think it's inescapable.
I think by way of a final question and closing our time together, if you pause and think now about us as upcoming lawyers out in the world, being practitioners in legal spaces, what are your hopes and what are your fears for us?
I think that every new law graduate should feel excited about the possibilities. A legal qualification or a career in law should be seen as rich with opportunity. And I've often said to lawyers that have been in practice for 4 or 5 years, try something else. There are all sorts of ways in which you can deploy your skills, and you want to make sure you end up doing something you're absolutely comfortable with and you're being the kind of lawyer you want to be. Don't feel you've got to comply with anybody else's expectations in that respect. If you want to work for a big corporate firm, that's fine. If you want to work for a community legal centre, that's fine. If you want to work as a public sector lawyer, that's fine. Whatever you find gives you the greatest sense that you're using your skills to serve objectives that you believe in. And my experience at the court is that it has again opened up all sorts of opportunities that I didn't anticipate. And in particular, the opportunity to drive change from within the system, and the discovery that there are people all around the place who want to be involved in that change process. And we've, on the criminal law side, done a number of things which have quite significantly modernised, improved standards for how juries are directed, how forensic evidence is presented. That, I think, is the thing I'm most satisfied about. But again, it wasn't planned. It kind of happened because I saw some things that weren't working very well, talked to a few people, and we agreed, yes, let's get together and fix it. And we've tried.
I think it's really interesting how there was that sort of continuing thread throughout our talk with Justice Maxwell about how often it's the unplanned things, the things that you don't come to with an agenda, and the things that you didn't necessarily expect that end up leading to some of the most interesting opportunities and some of, the greatest achievements that you're most proud of.
Yeah, that's a great point. I think he kind of touched on the fact that he maybe initially didn't even think he was going to get law, or, didn't expect, his law school experience wasn't amazingly positive.
Which is, very relatable.
Yes.
Everyone listening, I'm sure.
Absolutely. The imposter syndrome is very real for many of us. And I think, I think it was really encouraging that he just talked about the fact that once he was out there with real people, real stories, he felt like an enthusiasm and things fell into place. I thought that was a great encouragement for us in our journeys here. And his career was non-linear, which was really nice.
Yeah, he did a lot of different, things. He worked as a barrister, obviously now he's a judge. And then he also spent some time in the political realm as well. So I think that's a great reminder, because I think these days it's even more like that you can do a lot of different things in your career. And if you end up going down one track that you weren't expecting, that doesn't mean that you won't get back to where you thought you would be later. Or maybe you'll end up liking that track more than what you thought you wanted,
Absolutely. He talked a lot more about his beliefs or his views on social issues than I expected. And I found that really encouraging, that we can perceive, and I think law school again teaches us that morality, ethics, viewpoints, personal convictions are very separate from the law. And while I think that's true to a degree, that there is or could be or should be or whatever, a separation between the two, in reality, there's very much an intertwining, a mixing of them. And I thought it was really lovely just to hear his views on that.
Yeah, me too. I thought it was especially interesting because I thought he had a really nuanced view of what defending what you believe in means, and how it's not always as simple or clear-cut or black and white as you might think or as you might hope. And the examples of some of his freedom of speech cases really kind of demonstrated how sometimes to defend a principle that you really strongly believe in, you have to defend someone or certain actions that you might not agree with. But advocating for that person serves a larger goal that you're interested in being in service to and that you want to promote. So I thought that was interesting because that really kind of showed a nuance that I think we don't necessarily always appreciate, and that I think law school really needs to try and help us grapple with maybe a little bit more, because we're going to come across those conflicts as lawyers very often, and especially in a space like human rights. And it's really valuable to learn how to kind of reconcile that, I think.
Yeah, I think great thoughts. I'm thinking it's probably time for us to wrap up, and this has been an amazing discussion. We've been really interested, I think, and encouraged by what we've heard with Justice Maxwell's perspectives. Hope you have too. And I guess until next time, we'll sign off.
Yeah, until next time, guys, I hope you found that really encouraging and that you learnt a little something. I know I did. Have a great day.
Yeah, bye.